Hello, and welcome back to Organized, the Business Law Breakdown. I'm Professor Seth C. Oranburg, and today we're continuing our exploration of general partnerships. And we're going to talk about the default structure that are provided by law. Partnerships are described as flat organizations because, as a default, they're egalitarian. Unlike corporations, which are notably hierarchical, where roles and responsibilities are tiered and defined by formalities, partnerships operate on principles of equality and shared control. This structure can be empowering for partners, but it's also a source of potential conflict, especially when the parties don't realize this going into it. So in this lecture, we'll examine the default rules that govern decision-making, profit sharing, and other key aspects of partnership management. And we'll be looking at this under the Revised Uniform Partnership Act, or RUPA, which is dominant under American law. The default rule under RUPA Section 401 is that all partners have equal rights in the management and conduct of the partnership business. And this means that each partner has an equal vote in partnership decisions. Now, that's true regardless of their financial contribution, and it's true regardless of the nature of the partner's work in the business. To give you an example, a partner who invests $1 million in a partnership has the same say in decision-making as one who invests only $1,000. Now, that's totally different from a corporation, where instead of one person, one vote, like a partnership, a corporation is one share, one vote, and you have to pay money for your shares. So a person who invests $1 million and has 1 million shares has a lot more voting power than a person who invested $1,000 and has 1,000 shares. Decisions that fall within the ordinary course of the partnership's business are made by a majority vote. So if there's 3 partners, 2 of them can decide what the business is going to do. And again, that's true regardless of how much money they've put in or what their day-to-day roles are. As a matter of law, extraordinary matters, such as amending the partnership agreement or liquidating, selling the business, those require unanimous consent. Again, these are just default rules, and they reflect the principle that partnerships are built on mutual trust and cooperation. But they can be modified by agreement. And it's important to note that because if the partners don't want this to be their relationship, they can change it. They may, of course, not realize they have formed a partnership, in which case they're governed by the default rules, and that's why it's important for lawyers to know these. And many partnerships don't think about all these issues, so the default rules apply. There's also limits to how much you can modify any given organizational structure. So if you want to have a truly hierarchical structure, maybe a partnership's not the best choice. It would take a lot of contortions to make it work like a corporation. But all that said, the key thing is beginning to understand the default rules of partnerships because it tells you something about what's intended by this organization. And the idea here is the partners are equal. One partner, one vote. And if they want to have something different than that, they should modify their rules through a partnership agreement if that isn't practical or fair. By default, partnerships allocate profits and losses equally too. Profits and losses meaning how much money the business earns, and also if there's any debts that exceed how much money the partnership has. And again, that's true regardless of their contributions, which can also seem a little bit odd. Going back to the example of one partner put in $1 million and the other put in 1,000, they both have equal rights to the profits of that business, which may be surprising, but again, they should consult a lawyer, hopefully you now know this, in order to make sure that their partnership agreement actually reflects the allocation they'd like for profits. It's also true for losses. So even the person who only put in $1,000 is just as responsible for all the partnership's debts and losses. And that's what we mean by joint and several liability. So again, we see partnerships are built around equality. One partner, one vote, one share of the profits, one share of the losses. And this equality can lead to tensions if one partner feels or is contributing more labor, more expertise, or more capital than the others. In a partnership where one partner works full-time managing operations and another provides only occasional advice, an equal split of profits might be inequitable. Even though it's equal, it might be unfair. Partners can and should negotiate profit-sharing arrangements that reflect their respective contributions and memorialize their understanding in a partnership agreement, because the goal would be to avoid disputes. It's also worth noting that profit sharing is closely tied to liability for losses. Just as profits are divided equally by default, so are partnership losses, which means that every partner is equally responsible for covering the partnership's financial shortfalls. And for that matter, bad decisions. So if one partner gets into a contract under the partnership's business, the others are responsible for paying it if the partnership can't make the debt. And again, that's true whether or not a partner has contributed more or less capital or labor. The flat egalitarian structure of partnership has advantages. It allows for flexibility, and it can map to what people expect in a partnership where they sit around a table and vote together. And partners can adjust their roles and responsibilities. They can do this without formalities or hierarchical approval, which is a structure that's appealing to small businesses and startups. If you need to make decisions quickly and you don't want to be responsible for having a lot of formalities or for having a corporate secretary, which is keeping minutes and making sure you track with all the corporate law, this is a partnership structure that can be appealing. But in exchange for that freedom, you have responsibility in terms of unlimited liability. The other advantage is that this type of arrangement fosters a sense of shared ownership and shared responsibility, because that's literally true. That can strengthen the partnership's cohesion and long-term success because everyone has an equal share. But the flat structure, as mentioned above, can be a source of tension. Equal management rights mean that disagreements can quickly escalate into deadlocks. If you have two partners and they can't agree, what do you do with the business? If there's no mechanism for resolving these kind of disputes, the partnership might be unable to move forward and has to dissolve. Similarly, an equal allocation of profits and losses might be inequitable, and it might lead to resentment if one partner feels they contribute more than their fair share, or if they don't expect to be responsible for such big bills. These challenges underscore the importance of customizing the partnership's governance through a written agreement. While the revised Uniform Partnership Act provides a useful set of default rules, these rules are not mandatory. Partners have significant flexibility to structure their relationship in a way that best suits their business. And as an attorney for partnerships, one of your main roles is helping them figure this out. For example, a partnership agreement can allocate profits and losses based on contributions rather than equally. It can designate specific roles and responsibilities, such as appointing one partner to handle day-to-day management, or requiring a supermajority for significant decisions instead of unanimity. These modifications not only help prevent disputes, but they provide clarity and efficiency in the partnership's operations. And it's helpful for the partners to have one place they can look, the partnership agreement, to figure out their rules. It's a little bit hard to have to look up the revised Uniform Partnership Act and comb through it every time you have to figure out how things work. So it's just one of many reasons why having a defined agreement is a good idea. But in any event, this has been about the default structure of partnerships, and the default structure of partnerships is designed to promote equality and shared responsibility. While not without its challenges, these rules provide a foundation that is suitable for the partnership type of relationship. If you don't like that type of relationship, we'll certainly learn about other organizational types that you can select. Customizing a partnership's structure through a written agreement is essential for assuring fairness, and it can help resolve and, in fact, avoid potential disputes. But you can't contort a partnership into something that looks completely different without a whole lot of legal machination. And so if you want to have a totally different structure, you might pick a totally different form. In any event, as you reflect on today's lecture, consider this. When does the flat structure of a partnership work well? What type of business people would like to be in a partnership? And when would they prefer to have a different structure? How would you advise a client to navigate these default rules? Well, I hope that helps you understand the partnership rules defaults. Thank you for joining me today on Organize, the Business Law Breakdown. I'm Professor Seth C. Oranburg, and in our next lecture, we'll explore the authority and agency of partners. Until then, take care.